Hello and good evening everyone. So today I'm actually talking about the 7 years route to settlement in the UK for children who are born in the UK and subsequently leave to remain for those parents of those children who are born in the UK, and they basically aim to apply for leave to remain in the UK based on their children's 7 years residency in the UK. The question I get to hear quite a lot nowadays is whether this rule still exists, whether it is still in place or whether it has been scrapped. Well, the answer to this question is that the 7 years route for children born in the UK and for children not born in the UK is still in place. There is no such legislation, there is no such update to immigration rules which can rule out that this route has been scrapped. The only problem is that we are experiencing nowadays is that the Home Office is refusing applications, and the reasons for refusals is obviously the Home Office is exercising a much greater discretion in their favor rather than that they were doing previously in favor of applicants. The question comes that why is the Home Office refusing these applications, and if the Home Office has refused it, then what's the next course of action? So well, if you're in a similar situation, I would like to clarify one thing over here. As we have been experiencing from the past few years that these 7 years residency applications, Home Office basically used to grant them, and subsequently later on Home Office used to grant leave to remain for parents as well. But now the Home Office is basically taking a very strict approach towards the immigration rules which are already in place for this appendix private and family life. There has been no changes to the rules. There has been absolutely nothing which we can say that the rules have been updated or amended. The only thing is that the Home Office is taking a very literal interpretation of the rules which are already in place. So basically the Home Office is actually taking numerous factors into account, and subsequently they are refusing some applications. So what to do in this similar situation? So if you're in a similar situation, and what I would advise over here is that rather than doing it all by yourself, rather than taking services of some unregulated agent or some consultant, the only solution to this problem is that you seek authentic legal regulated advice. Because what I'm trying to say over here is, I'm not saying that the lawyers are a solution to every problem. No, because these type of things, these type of cases, when the matter becomes a bit complicated, bit complex, these are the things that the lawyers are trained for. Your legal representative, whoever he or she may be, they spent years studying at a law school, they spent years studying at a law degree, then they move on to their career progression and so on. So lawyers are basically trained to do this stuff, and basically lawyers, the knowledge that lawyer or legal representative have, an agent or a consultant will not guide you according to the legal principles. So things have changed quite a lot. The rules are same. The rules have not changed, but the time has changed. The way Home Office is dealing with the applications, that has changed now. So if your application has been refused based on 7 years, based on your child's 7 years residency in the UK, it is likely that you must have been granted a right of appeal. If you have a right of appeal, then please note that within 14 days from the date of decision that you have received, you need to appeal to the first year tribunal. If you do not, it might involve much more complications in the future. The complications can involve you apply for out of time appeal, the court might not accept it. If they do not accept your out of time appeal, like if you apply after 14 days, you submit appeal after 14 days, then you have to do the application again. You have to pay all the relevant fees to the Home Office, IHS, all over again. So basically, if you do not appeal within time, then the process needs to be repeated, and again you are in a similar situation, and the wait time on these applications, as you know, is quite long. And similarly, even if you appeal, the wait time for appeal hearing to be listed, what I can say that I can see nowadays is average wait time for appeal hearing to be listed from the date of submission is about 1 year. If you are in a situation, if you want to apply for a visa for yourself based on your child's residency in the UK, immediately seek legal advice before you put any application to the Home Office, because remember, an authentic legal advice can save you many troubles. Thank you.